The 2010 Atlanta Press Club Debates, brought to you live from Georgia Public Broadcasting. Tonight, the race for Georgia Supreme Court Justice.
And good evening. I'm Jonathan Serrie, a news reporter for Fox News in Atlanta. We welcome our television viewers and our live studio audience to the 2010 Atlanta Press Club Debate Series, originating from the studios of Georgia Public Broadcasting. This is the debate among the candidates in the nonpartisan race for Georgia Supreme Court Justice. Now let's meet the candidates. They are in alphabetical order. Tammy Lynn Adkins is a divorce attorney from Lawrenceville. Ms. Adkins declined our invitation for this debate. She is represented by an empty podium. David Nahmias was appointed to the Supreme Court of Georgia by Governor Sonny Perdue in August of 2009. And Matt Wilson is the founder and managing partner at the Wilson Law Firm, a 20-year-old litigation law firm and a member of the Atlanta Bar Association and the Georgia Trial Lawyers Association. Here is our format. In the first round, each candidate will answer a question from one of our three panelists. In the second round, the candidates will ask questions of one another. Each candidate will have time for rebuttal in this round, and in the third round, the panelists will continue questioning the candidates. Finally, each candidate will have 30 seconds to make a closing statement. Before we get started, let's meet our three distinguished panelists selected by the Atlanta Press Club. First, we have Charles Edwards. He is a reporter and producer for WABE 90.1 in Atlanta. Next, we have Robin McDonald, staff reporter for The Daily Report. And our final panelist is Sandra Parrish, a reporter for WSB Radio. Now let's get started with the debate. In the first round, each candidate will be asked a question by one of our panelists. The candidates will have 60 seconds to answer each question. As a moderator, I'll determine if a rebuttal is necessary. By random selection, Matt Wilson gets the first question from Charles Edwards. Charles?
Mr. Wilson, you've been quoted as saying that Mr. Nahmias is obviously the wrong man for the job. What do you mean by that, and why would you make a better justice than Mr. Nahmias?
It's a reflection of the experience. This is a Georgia court with Georgia laws, Georgia constitutions, and it regulates the practice of law in Georgia. I have 35 years of experience in Georgia trying cases in Georgia courts. The federal prosecutor has no such experience. I've spent 28, 29 years with Georgia's laws and constitution. The federal prosecutor has none of that experience. I've been a practicing lawyer and have had approximately 1,000 clients, handled several thousand matters for those clients all over the state of Georgia, a very diverse group of clients. The federal prosecutor's had no such clients. He's only represented the federal government. So I believe that from an experience perspective, I am distinctly the better qualified candidate. Thank you.
Mr. Nahmias, rebuttal.
Qualifications are relevant to being an appellate judge. We're not trial judges, we're not trial lawyers. I actually have far more appellate experience and expertise than Mr. Wilson. And in the state bar poll, 95% of the respondents said that I was well qualified or qualified to serve as a justice, as opposed to a third of the respondents who knew Mr. Wilson who said he was not qualified. My experience goes back to clerking on the Supreme Court of the United States, and the best experience you can have is having actually done the job as a justice of the Supreme Court of Georgia.
And Robin McDonald, it's now your turn to ask David Nahmias a question.
Mr. Nahmias, should a judge recuse from a case if he has accepted a campaign contribution from anyone appearing before him, and should judges be allowed to make campaign contributions to other candidates? Why or why not?
Well, in the first part of that, I don't think any campaign contribution warrants a recusal. These are statewide elections. To be able to inform the electorate and prevent your opponents from misinforming the electorate, you have to raise money to get your message out. I've concentrated on reaching out very broadly, and my financial support, which I don't solicit directly, but I know comes from almost 500 individuals across the state, across the legal community, from both parties, from firms, from solo practitioners to the biggest law firms. So obviously, if you have a single segment of support, that can raise some concerns, but my support is so broad I don't think it raises recusal concerns. On the issue of judges giving other judges campaign contributions, I haven't really thought about it. I don't think I've taken any or that I know of.
Or anyone, not just other judges.
Judges giving anyone?
Anyone.
I wouldn't do it.
Thank you.
Mr. Wilson, a brief rebuttal.
Well, I think the real issue that the Georgia voters need to focus on is the tremendous conflicts of interest that the federal prosecutor brings to this job, where $1 million a year comes into his household from big corporations and big business. I think that that's the conflict of interest, and that it greatly supersedes the question of who's financing this campaign. Thank you.
And that concludes round one. Now the candidates get to ask a question of each other. You have 30 seconds for the question and 60 seconds to respond and 30 seconds for rebuttal. By random selection, Matt Wilson asks the first question. Mr. Wilson.
You've claimed to be tough on crime and be against political deals. Yet when we look at your history as a prosecutor, you cut a deal with the rapper T.I., who was found with a machine gun. He was a felon. That's a serious charge, yet he gets a slap on the wrist, community service. Now he's in trouble in California. When 3 policemen invade Katherine Johnson's home, they gun her down, leave her bleeding on in handcuffs, fail to bring her aid. You do nothing. The neighborhood is in an uproar. The newspapers finally uncover the evidence.
What's your question, please?
How can you claim to be soft on crime when what it looks like you're doing are blatant political deals?
Well, Mr. Wilson, you obviously know little or nothing about either of those cases. In the T.I. case, he was caught and he was required to plead guilty. He spent a year in federal prison, another year on home confinement, and he did enormous and very valuable service reaching out to children to try to educate them not to get into drugs and gangs. Now, he allegedly has committed some additional crimes. All the risk of that deal is on him, and if he did that, he's going to pay a price. In the Katherine Johnston case, we aggressively went after the police officers responsible for her death. It is exceptionally hard to get police officers who kill someone to come forward, admit what they did, and we were able to convict them of civil rights homicides in federal court. They all serve significant sentences in federal custody. And all anyone has to do is concerned about my 15-year record as a federal prosecutor is look at it. The idea that I've ever been soft on crime is simply ridiculous, and anyone who knows the facts wouldn't even dare to make that allegation.
I would like the rebuttal. The record is a felon with a machine gun gets a year in jail. Police officers who gunned down an elderly woman and let her bleed to death in their home get a short term. They plead not to homicides but to a civil rights violation, get 5 years in jail. That's simply not soft on crime. That is soft on crime, and that reflects political deals.
Nor is it true.
Mr. Nahmias, your turn to ask a question.
Mr. Wilson, a major issue for Georgia's appellate courts is our complicated rules and decisions on jurisdiction and procedure, which govern which appeals go to the Supreme Court, which appeals go to the Court of Appeals, whether the right to appeal is discretionary or automatic. These rules often leave citizens who represent themselves in court completely lost, and they can even confuse lawyers and judges. And as a result, sometimes people lose their right to appeal. What would you do to improve the appellate legal process?
I think the focus on the appellate legal process fails to recognize that our appellate decisions affect the trial judges and the trial courts and the people of this state, the average individuals of this state. Of course, we have complex rules, and those rules should be simplified so that it's clear that when a trial judge makes an error, the affected individual has a right to appeal and bring it to the Court of Appeals. When a constitutional question is involved or the appropriate questions are involved to come to the Supreme Court, they do so. But what your experience fails to recognize is that there's a real world out there of people. The rubber meets the road in the trial courts. That's the experience that I bring. I've been to the appellate court. I've been to the Supreme Court with appeals. You've had no experience trying cases in the trial courts of the state of Georgia.
Mr. Nahmias.
I actually have tried cases before juries consisting of Georgia citizens in Georgia courts. They were federal courts. I have the experience there, but I've also served as a justice and written more than 70 opinions and joined more than 300 and voted on more than 1,500 other matters in the Supreme Court. Mr. Wilson says he has appellate experience. He's been practicing for 35 years. He has yet to have a single published opinion on one of his cases from the Georgia Supreme Court. You're not electing a trial judge or a trial lawyer. You're electing a Supreme Court justice, and that's the relevant experience, the experience I have.
That concludes our second round of questioning. For those who may be joining our program in progress, this is the debate among the candidates for Georgia Supreme Court Justice. For our third round, we return to our panel of journalists who will ask questions of the candidate of his or her choice. Candidates will be allowed 60 seconds to respond. As moderator, I'll determine if the opposing candidate will be given 30 seconds for rebuttal. We begin this round with a question from Sandra Parrish.
This is for Mr. Nahmias. The U.S. Supreme Court heard arguments this week regarding the protesting of funerals by members of the Westboro Baptist Church. What are your thoughts when it comes to free speech rights versus those of a family to privately grieve?
You know, you get a lot of questions in judicial races about particular issues, but I don't think judges should state a position on any legal issue that may come before their courts for two reasons. One, if you state a position when you become a judge or as a sitting judge, I would have to recuse myself from the case. And secondly, it suggests that your predisposition or your views should matter. And under my judicial philosophy, they shouldn't. I think anyone who's been a judge or a lawyer for a while knows until you look at the concrete facts of a case and actually research the law, it's very hard to figure out where you come out. And you need to also hear the arguments of the parties with an open mind, listen to your colleagues. So if that case were to come before us, which it won't, it's in federal court, that's the process I would go about. But I don't think it's appropriate, unlike some of my opponents, to state positions on issues that may come before the courts.
Would you like to rebut?
Please. I think it's important not that we look at cases that may come before us. That's improper for either of us as candidates to discuss or to state positions or make promises. I think it's important in this debate that we look at the cases that have been decided. We look at this justice's, this federal prosecutor's record on the Georgia Supreme Court, because based on the experience we understand with his cases, that's what the Georgia citizens and voters need to examine.
Charles Edwards.
Mr. Wilson, in your questioning of Mr. Nahmias, you brought up the Catherine Johnston case, and you made a reference to Mr. Nahmias sort of brokering sweetheart deals here. There were federal charges in that case against one of the officers, Mr. Tesler. If you were a federal prosecutor in that situation, what would you have done differently?
I think that I would have prosecuted, first of all, I would have allowed the state of Georgia to prosecute those matters. That's where they belonged at first instance. These were homicides. This was a homicide committed in the city of Atlanta by Atlanta police officers. It should have been prosecuted as a homicide. And that would have been the first decision that I would have made as a federal prosecutor. But I'm not running to be a federal prosecutor. I don't have experience as a federal prosecutor. I'm running to be on the Georgia Supreme Court. That's the experience that I have in bringing to that office. Thank you.
Mr. Nahmias.
Well, of course, the only one with experience on the Georgia Supreme Court is me, but Mr. Wilson simply doesn't know the facts. Actually, Catherine Johnston's, the police officers who were responsible for her death were prosecuted in state and federal court. They pled guilty in both courts on the same day. The third officer will be allowed to go to state court first, where they tried to prosecute him for homicide, but the grand jury wouldn't indict him. He then came to federal court, where we were able to get a civil rights homicide prosecution against him, and then he was sentenced. And I personally went to court to try to get a higher sentence. The federal judge went below our recommendation. But Mr. Wilson is just badly wrong on his facts, which makes you worry about someone running for judge.
Our next question comes from Robin McDonald.
This is from Mr. Wilson.
Thank you.
I've been reading your campaign website, which describes your opponent as a career federal bureaucrat with no trial experience in any Georgia court. Since your opponent has spent the better part of 2 decades either personally prosecuting or directing the prosecution of some of the highest profile federal cases in the state's history, are you being disingenuous, or do you believe all federal prosecutors are just bureaucrats and the federal courts in Georgia don't count as true courts of law?
I believe there's a substantial difference between the courts in Georgia and the courts in our federal system. The courts in Georgia are courts of general jurisdiction. They handle matters such as divorce, felonies, misdemeanors, property disputes, most contract and civil disputes. This is the area in which my opponent has no experience. The federal bench is a very different environment. An example is the difference between whether a case gets tried versus a case gets pled. The former federal prosecutor didn't try a case in the Kathryn Johnson matter. He took a plea. There's a difference between whether you are a trial lawyer and you try cases.
But with all due respect,
he's
tried a number of cases, and your website says any Georgia court. Are you exempting the federal courts?
Yes, I believe that the citizens of the state of Georgia understand the difference between the federal government and the state government. He has good experience with the federal government. He has no experience within our state system. This is a state constitutional office.
Mr. Nahmias.
I'm very proud of my service as a prosecutor. The reality is that prosecutors represent the people. I find it offensive that we get called bureaucrats. We stand up in court and represent the people. I represented the people of the United States, and for most of my career, the people of Georgia, in keeping violent criminals off the street, prosecuting public corruption and terrorists, a number of trials, including one of a sitting state senator in federal court who was convicted. And I represented the victims of crime, who are about the most important people in the justice system. So, you know, I'm happy if Mr. Wilson wants to call all prosecutors.
I'm sorry, I need to call time. Our next
fine.
question is from Sandra Parrish again.
And this is also for Mr. Nahmias. It seems funding has always been a sore spot between the legislature and the Supreme Court, and justices last year volunteered to, or this past year volunteered to give themselves 3 furlough days. And I wonder what else could be done to make sure that the funds that are available to the court are used in the most responsible way.
Well, we are part of the state government, and times are tough for everyone, and the money for the state government comes from the people of Georgia, and times are tough for the people of Georgia. We owe it to make the system as efficient and effective as possible. But the most important thing we do as Supreme Court justices is decide cases and try to write opinions that bring clarity and consistency to the law and are persuasive. And if we do that so that people can look at the law and understand how their disputes will be worked out, over time they don't need to go to court as much, and that's the best thing we can do for the legal system, other than making it as efficient as we can. And times are tough, and we are operating on as limited a budget as we can try to do.
Mr. Wilson, you want to weigh in?
I've had 20 years of experience as a small businessman making payrolls. I understand fiscal constraints. I'm a fiscal conservative. I understand the issues that are facing our trial courts, which is where the vast majority of the state budget is expended in the courts. It's important to bring someone who has that type of experience to this important constitutional office. Thank you.
Next question from Charles Edwards.
Staying on the topic of funding, but moving towards the public defender system in Georgia, the Brian Nichols case really brought out a lot of passion within the legal community as far as how far the state should go in defending someone who is accused of a crime but can't afford their own legal counsel. Where do you all think that line should be drawn?
Is it?
And you can start, Mr. Nahmias, and then also go to Mr. Wilson.
I think those are difficult questions. Those cases come before our court with regularity, and so I'm hesitant to give any detailed answer because we actually have a number of those cases before our court. The bottom line is that criminal defendants under the United States Constitution, by Supreme Court decision of the United States, which we have to follow as state judges, are entitled to an adequate defense. Defining adequate is difficult. They're not entitled to a gold plate defense, and they're also not entitled to no defense. And you know, you have to decide that in a largely case-by-case basis. The policy decisions about how the funding should occur are really matters for the elected branches of government, their legislature and the executive.
But can you define gold plate defense? What do you mean by that?
Well, you're not entitled to all the money you want in your defense, just like it's not adequate to give you no money. But drawing the line in between is a very difficult task that we do on a case-by-case basis, and it's hard to get much more specific without requiring myself to recuse from deciding those cases.
Mr. Wilson.
These are difficult matters which may well come before the Supreme Court, so I can't comment and make promises. It is clear that in our state, the funding issues belong in the legislature, not in the courts. My opponent has repeatedly misunderstood that boundary and has engaged in legislation from the bench. I hope we can talk about his case record tonight. Otherwise, I think that that's a matter for the legislative branch.
I need to call time. My apologies. And Robin McDonald, your question.
This is from Mr. Nahmias. The state Supreme Court oversees the Judicial Qualifications Commission, which disciplines the state judges for misconduct and conducts a large part of its work in secret. Should the JQC be more transparent in informing the public about disciplinary actions it takes against state judges, or is the secrecy warranted?
Well, we oversee the system only in the sense that their decisions come to us for ultimate judgment. The rules of the JQC are set by the JQC, and the JQC operates largely independently of the Supreme Court. Much like the State Bar, we have the ultimate control over the final dispositions when they come to us. There's only been one case of the many in the last year that actually reached the Georgia Supreme Court. I'm a believer in transparency generally. One reason I like to write longer opinions is I think we should explain what we do. But there are also considerations on the other side when someone is being investigated to make sure that someone, if a complaint is not have some basis, that it doesn't go forward. It's a similar situation to most professional discipline. But generally, I believe in transparency, and certainly if it reaches the point where there's an active dispute between the parties, I believe that should be public.
We have time for one more question from a panelist.
Could I have a rebuttal on that one,
Sandra,
please?
We'll give you a brief 30-second rebuttal. Go ahead.
The judiciary in the state of Georgia is in some degree of crisis. Transparency would be enormously important. We've had judges having sex with prisoners in their custody in jails. People have known about this. They have had to have known about this. We have had judges taking payoffs to let people out of jail. The community has got to have known about that. Transparency will help, and it's the only solution to this problem. Thank you.
Sandra Parrish.
This is for Mr. Wilson. With your years as a trial attorney, have we become too much of a litigious society where it seems everything from a dispute with your neighbor to accusing your doctor of malpractice is all just decided in court?
Absolutely. And as a justice, I will advocate the alternative dispute resolution techniques which we have recognized to reduce that load. That's part of why we're having a crisis in our courts. We have too many disputes, and we have petty disputes, and it pushes aside the serious disputes and the time for the serious disputes, pushes aside the important questions of child custody, of important questions that come up in domestic relations. I am the only candidate in this race who is a trained mediator and who's experienced in mediation. Mediation is a wonderful opportunity to empower the litigants themselves to reach resolutions which will help and work for them.
Unfortunately, we have no more time for questions or rebuttals. Each of the candidates, however, in the nonpartisan election for the Georgia Supreme Court will now have 30 seconds for a closing statement. As a reminder, Tammy Lynn Adkins declined our invitation to this debate. Matt Wilson was randomly selected to make the first statement. You may begin.
I am an everyday Georgian. My values are those of family, church, service, honesty, and integrity. I'm a Boy Scout adult leader. I was chosen by my church as a scoutmaster. These are the values I'll bring to the Supreme Court of the state of Georgia. I believe that if the people in the state of Georgia will honestly look at the judicial record of my opponent, they will see that he is an activist judge who's been legislating from the bench, and that's what the other judges on the Supreme Court have said about him. Please vote for me. My name is Matt Wilson. Thank you very much.
Mr. Nahmias.
Well, thank you for watching this evening, and thanks for being interested in this very important election for the future of Georgia's justice system. I'm the only candidate for Supreme Court justice with a proven record of expertise and experience in the appellate court system, fairness and integrity, a record of dedicated public service for nearly 2 decades, enforcing the rule of law, a record that's earned the trust in support of Georgians from all walks of life. Please visit my website at justicenahmias.com to learn more about our campaign, and please vote for David Nahmias as your Justice of the Supreme Court. Thank you.
And that concludes our debate. We'd like to thank our candidates, Matt Wilson and David Nahmias, and also our distinguished panel, Sandra Parrish, Charles Edwards, and Robin McDonald. The general elections are coming up on Tuesday, November 2nd, and early voting is ongoing. Again, our thanks to the candidates and to our panel of journalists. We'd also like to thank the Atlanta Press Club for arranging this debate. For more information about the Atlanta Press Club, you may visit atlantapressclub.org. The debates that air on Georgia Public Broadcasting will be archived on the Press Club's website. This broadcast has been streamed live and will be available on demand on GPB's website. You can find that at gpb.org. I'm Jonathan Serrie. Thanks so much for joining us for this debate. We invite you to stay tuned for the debate with the candidates for the 7th Congressional District. That debate is coming up next.
The Atlanta Press Club Debate Series is made possible in part by donations from the late Tom Watson Brown and Emory University.